number 127, matter of Mintz versus Board of Elections of the City of New York. Counsel.
Thank you, Your Honor. Could I reserve 2 minutes at the end? I'm not sure if that's
Yes,
proper
of course you may.
procedure. Thank you very much. Your Honors, I first, it's an expedited procedure in getting our briefs here. And I'm going to talk about two cases, or one case at least, that I didn't cite in my brief, and I handed it to the clerk. I have 7 copies if the court wants. I believe that it's important. I mean, you guys hear tons of election cases where issues of content and form and whatever. And I spent the weekend looking to see whether this court had any decisions where it talked about the impact of the 1992 and 1996 amendments to the election law on this strict compliance and what had to be strictly complied with or not. And I couldn't find any. The Bosco case, which the respondents rely on, and which this court just affirmed based on the opinion below, said the Court of Appeals has repeatedly held that there must be strict compliance with statutory commands as to matters of prescribed content, and that was in 1984. Then I found a decision out of the second department, the third department, 190, it's Hogan versus Goodspeed, 19680 second 675, where the third department stated that the content rather than form rule, and then they cited a long line of Court of Appeals cases, has been, quote, legislatively overruled by the new election law. No longer are the courts permitted to abort candidacies and disenfranchise voters as a result of an innocent violation of some technical requirement having no logical bearing upon the underlying purpose of preventing fraud. This decision, which was in 1993, so 9 years after Bosco, was unanimously affirmed by this court at 82 New York 2nd 710. This case is a perfect vehicle, we think, to emphasize what the court affirmed in 1993 and to apply the line of cases that we cite at page 17 of our brief, which allows a designated...
Counsel, just for clarification, where is the requirement of the reference to female?
Where is
that requirement? That it must include the word female, the petition?
It isn't. There is no requirement.
So where is that coming from, that you have to identify as female? That word must be deployed.
Section 2-102 of the election law states that where a party has a rule that requires male and female, it says the petition, quote, shall list candidates separately by sexes. That's it. Section 6-132, which talks about content, simply says you have to put the name of the position. So what the dissent said here and what we argue is that the name of the position, as per the Democratic Party rules, which are in the record, is member of the state committee. Then in a separate line it says each assembly district shall elect a male and a female to such position. It doesn't say there shall be 200 male state committee members and 200 female state committee members. And that section 2-102 that Judge Ed Mead relied on, and the first department simply, the majority simply said for the reasons that Judge Ed Mead stated, which was Bosco, it says it shall list candidates separately by sexes. Now the petition here had one candidate on it. There was no ability to list them separately by sexes. The letter filed by...
Now, there would have been an ability if you had listed it, that there is a male, I mean, the male and female are elected at the same time. So
if it
the fact
was
that
the
she may not
ballot.
be running in a slate with a male
Right.
doesn't necessarily relieve her of the burden to identify herself as the female candidate.
So in a petition that has more than one candidate, which the interveners attached a copy of one to their letter, where there was a male and a female running on the same petition. It said male and female. In this petition, there was one, so it said must be listed separately. It doesn't say must have the word male and female. It
But
says,
how is it, how are you suggesting it's listed separately? You mean on the petition itself with only one candidate, that's a separate listing?
it has to identify, if there's two names, it has to identify one, who's a male and who's a female.
Well, but that's not what it says. It says that the petition shall list candidates separately by sex.
Right.
Right? Okay. So if there are two candidates are running, but they're, as they were here, but they run on separate petitions, you're saying that that each petition does not have to identify the sex or gender of the person who is seeking?
So this is why I think this is a good case to talk about whether we and this court continues. I mean, most of the cases come up here are about whether we're going to strictly comply or substantially comply, liberal construction, strict construction. I assume I do election law, that's what often the cases turn on. Here, if one uses the liberal construction rule, then there's a whole line of cases that say, look to the petition. It says a designating petition should stand if it, quote, this is all the cases on page 17 of our brief, sufficiently, if the petition is sufficiently informative so as to preclude any reasonable probability of confusing or deceiving the signers, the voters, or the Board of Elections. Now here, we say that a petition by someone named Penny was sufficiently informative to tell people that she was a female. The Board of Elections itself, when she filed, put her down as a female. They published a list for 2 weeks.
Well, that's the clerk, the administrative clerk who takes it. It's not a ruling by the board at that point.
I understand it's not a ruling by the board, but the reaction of the clerical people in the Board of Elections was to say Penny, female, just like the voters. So the question, it's not reasonable probability, it's not all probability, it's reasonable probability that the voters will not be deceived by what they're reading on the petition.
So in a case where there was a name that wasn't so readily identifiable, we would have a different outcome?
Yes, you would have a different
So we
outcome.
would be doing it
If the name
name-based.
was, my wife's name is Kelly. Kelly could be a male or female.
So it would really depend on how you view your name. So if I feel that my name won't cause confusion, then I don't have to do that.
Well, I don't think it's whether your name, if you think your name won't cause confusion, it's whether a reasonable person.
So we would be passing on that. So a name that might be closer, we would have to say, well, that name, a reasonable person. Don't you see there would be a problem with that?
But I think that that's true on every one of these issues where someone describes a position wrong, they say
This
associate.
is a gender description. So you're asking us to assume a name is associated with a particular gender. That's what we would have to do.
Yes, I'm saying that if you look at the petition as a whole, that the name Penny suggests
It
female.
seems we'd be
So
trapped
if
by...
somebody, I'm
Oh,
sorry.
go ahead, Judge. No, you're fine. Finish your thought.
So what if it's a foreign name? When I say foreign, I mean one that is not common to traditional speakers of English. Then what? I mean, do you understand the danger of the rule you're proposing?
But it's not a dangerous rule. Most of what judges do, just like the Board of Election has to do, is they look at facts and they make decisions based on what's in front of them.
But as a policy matter, would we want to put our judges in that position rather than put what seems to be a not significant burden on someone going out and getting 1,900 signatures to list their gender?
But here, so again, this is if we're going to do the strict compliance, which is like, hey, you didn't put female, or you're going to apply a reasonable
I think you're
standard.
confusing a little bit there, the standard with, whatever standard we're using, let's say it's a looser standard than strict compliance. To me, if you don't use the name, and you have two slots open, a male and a female slot, and you go out with a petition, and you get people to sign it, and they don't know which of those gender slots you're running for, and put the name aside, they could be supporting a candidate for the female slot. You're not identifying which of those two slots, so I'll sign your petition. Maybe it's a different slot, it's just member of the committee. So you're causing confusion there under any standard if you don't look at the name.
But people look at, this is a one-person petition. It's not like a list, and somewhere down the list, there was a name that you couldn't identify. This was a one-person petition. Penny Mintz was at the top. Penny Mintz did most of the petitioning. She herself collected 500 signatures. And the circumstances the facts of the petition, and that 1,900 people signed it is particularly important. I don't want to lose...
Let me ask you this. Let's say that Penny Mintz, she identifies as a female, but on the petition it says male. What happens then?
If she identifies as female...
She herself that's how she recognizes herself. That's
Right.
how she lives in the world as a female. The petition says male on it. What happens then?
Well, that I think shows some underlying problem. Judge Edmeade talked about it, not in her decision, but when she was talking about it with the rule, because the rule doesn't recognize some stuff that's going on in society and in American society today.
Okay, but please answer my question. What would happen in that kind of case?
But again, we still have to go back to the facts. Is there a reasonable probability that people were being deceived when they signed her petition and she was running for female? I want to address one other issue before I lose my time.
Before you do that, this standard of potential confusion, reasonable possibility of confusion, have we ever applied that standard to a case where the legislature has said that certain information must be on a petition?
No, I don't think this court has issued a decision where it talked about the standard to apply since I couldn't find one since 1992. I want to just raise one other issue, the timing of this. The board acted 3 weeks after the petition was filed, not 2 days, like almost every other case that you have here. 3 days, no objection was filed. They acted 3 weeks later. There's a New York City only rule where they give themselves the power that doesn't derive anywhere from the election law, and we talk about it in our brief.
Did you preserve this argument?
Yes.
When did you assert this argument?
Excuse me?
When did you assert this argument?
I asserted this argument in the lower court. I asserted it in my brief, which the court has copies of in the appellate division. The appellate division didn't talk about it, and I reasserted it here. The board acted what they call the prima facie defect. Now, there's a state rule, the state board rules, that says they have to do it within 2 days, anything apparent on its face. Prima facie, apparent on its face, similar words. The New York City board created this Rule E that lets them, no time limit. So here was 3 weeks later, after the opportunity to ballot date had passed, where they decided, oh, we found this issue and we're going to disqualify. If they had done it in the 2 days, then at least there's no way that she could have fixed the petition. But she could have petitioned for an opportunity to ballot. And this court does have case law that we cite in our brief that the Hemley case, 20 New York
Doesn't
Second.
that 2-day rule just apply to compliance with the cover sheet and binding requirements of the regulations?
But that's the cover sheet and binding requirements. It's about, and it also says matters apparent on their face. There's nothing that gives a local board, there's no rule that gives the local board anywhere the power to just 3 weeks later, after all the petition deadlines have passed, after all the opportunity to ballot petition deadlines have passed, to all of a sudden discover a problem where there's been no objection. They do have the power to create rules, to implement how to deal with objections, but here there was no objection. In fact, the opponent didn't think she wasn't a female.
Thank you, Mr. Schwartz.
Thank you.
Counsel?
Good morning, Your Honors. May it please the Court, my name is Jane Gordon. Many of the questions that the Court posed just now arise because the dissent inappropriately relied on Election Law 6-132 to resolve this matter. that provision must be read in harmony with Election Law 2-102. And the only way to read them in harmony is that 2-102 governs when it's a mandatory legislative command, and 6-132 applies when it's a technical and non-substantive issue. That is the only way to harmonize those two provisions. And under that harmony, it is clear that this is a mandatory substantive command as provided by the Democratic Party call, which at least Packer v. Board of Elections, the second department case, ruled is where you find the name of the position. And the party call requires that it either be male state committee member or female state committee member. There was no compliance whatsoever here. So we never get to whether or not the petition was sufficiently informative because the candidate made no effort to comply. It would have been different if she had put the initial F up there. Then we might get into Section 6132 territory about whether or not that would be substantial compliance. But there was no compliance here.
If there's something else on it, though, that would lead one to believe that the individual is of one particular gender, does that resolve it? Does it boil down to this? You got to have the F, or you've got to have the M, or you have to have the whole word or part of the word?
Your Honor, anything less than something that says female or male is going to devolve into a subjective view of what a clerk deems is sufficiently feminine or masculine.
What if it said woman instead of female?
I think that gets into 6-132 territory. Is that substantial compliance? But we don't have any gender.
What about the symbols, circle with the cross or?
That's a question of substantial compliance. I'm not going to rule on that here, but at least an effort has been made.
Another day.
An effort
But
has
what
been
about
made to comply.
a name that generally is associated with a female?
Well-
Why doesn't that work?
Actually, I would say most of you may or may not know Penny Hardwick. A male. There are other men named Penny.
Okay.
I don't think that works. I think that's an unworkable solution because
Do
it's.
you think there's absolutely no name? No name at all that is strictly on one side of that ledger than the other?
Not today, Your Honor.
Not today.
Not today. In today's world where there are people who are non-binary, it's
if you're a
treacherous territory to go there.
What if you write trans woman?
I'm sorry?
What if you write trans woman on the petition?
That's an interesting question. But at least an effort has been made to identify by gender. That's actually a problem with the original
But
statute.
you think relying on a name that, yes, there may be some people who fit the other way, relying on a name that usually is associated with.
That's a very
with females or
Western-
women,
That's a
however you
very Western way of looking at things in a culture that is no longer Western-dominated, Your Honor.
What about the argument that 2-102-4 doesn't say identify the sex of, but says list separately by sex? So, for example, if I asked you, could you list the President of the United States separately by sex, and you gave me a list of all the presidents and didn't say male on it, would you have complied with that?
For looking at the petition from the public's point of view, which is what we have to do here,
Well,
because,
don't we have to look at the statute from the perspective of the legislature's point of view?
yes, but your proposition presupposes that everybody knows that there's not been a female president. I wish I could say that that's something that we can assume for people who are voters.
Well, suppose
I'm not sure we
I-
can
Take
give
an
you a-
office where you
give
have both,
I'm
where you've
sorry?
had a male and a female, and just replace that title for the one Judge Wilson suggested in his hypothetical.
Again, we have to go to what the Democratic Party describes the position as here, and it is binding, and it says it has to be male state committee member. That is the title for which she is running, the position for which she is running. She is running for male state committee member and female state committee member. She's
So
running
what
for
about the
female.
argument that the candidate missed the opportunity to ballot?
Well, I would argue that that is effectively an estoppel argument that was not preserved below, but even then, you can't stop the government from executing its lawful responsibility here. But as an initial matter, it's unpreserved.
Doesn't that, though, beg the question whether or not the Board of Elections process and rule is lawful? Maybe it's not, if it, as he argues, now makes it impossible for them to try and get a write-in candidate or get on the ballot some other way.
It was their own mistake that put them in this position, Your Honor.
So you're back
So
to
could they
preservation.
have, I'm sorry.
No, that's fine.
Could they have, in excess of caution, brought a petition to validate upon discovery of the error? Before the board actually had its final determination. In fact, this proceeding was commenced before the board actually issued its final determination, was it not?
Yes, it was.
So could they have done it even sooner? Or in order to preserve that opportunity to ballot?
I don't have the answer to that, Your Honor. I apologize. I don't know the answer.
Thank you,
to
counsel. Counsel?
Get my watch. Good morning, Your Honors. Roberta Kaplan for intervener, Rachel Levine. May it please the court. We actually did some research over the weekend too, Your Honors, and I've been ever since I got involved in this case, I've been fascinated by this question of how long this provision has lasted, how long it has been in the law. It's actually remarkably old. We think it goes back to the 20s. We talked to the reference law librarians in Albany, and there was apparently a fire, and a lot of legislative bill jackets were burned, so they can't conclusively determine it. But the understanding is that it actually originates with Eleanor Roosevelt, who required in the Democratic Party, initially in the state, and now it's the Republican Party as well, that there be equal representation for women. And that the view would be that if you have equal representation from women in the state party, a female state committee member and a male state committee member, that will increase representation of women in politics and in the polity. That's for another day, whether or not that actually succeeded, Your Honors. But it's an incredibly old statute. This language has existed in election law 2102 since at least the 30s. And we found a case that I handed to my friend, Mr. Schwartz, that's actually from a judge in Queens. I'll give you the site. Alexander v. Cohen, 169 Miss 151, 1938. This is a Queens trial judge. Actually first saying that he disagrees with this idea that there should be male and female slots for state committee, but putting that aside, this is what he wrote. He said that the point of the law was to clearly define which of the candidates are women and which are men. That is particularly so, whereas in this instance, the voter may vote for two or more candidates to be elected at the election for the same office or party position. This only gives the voter information to which he or she is entitled, viz. The sex of the candidate. Section 11 of the election law, insofar as it authorizes the separation of designees and candidates by sexes, is a proper exercise of legislative power, not inconsistent with constitutional provisions treating with the suffrage and the right to hold office, especially when it is considered that given names of men and women are not always clearly indicative of sex. That's in 1938, Your Honors. It was a very different world, and I would argue that in 1938, things were much more indicative of sex by name than they are today. All the issues that you've identified with respect to names not being clear and having a sua sponte kind of case-by-case rule is exactly why election law, the election law section that we're talking about says what it says. It's exactly why this court in Bosco held what it held. After all, in Bosco, the names were pretty obvious. It was Imogene Mayer. I think everyone knew that was a woman by name, and an F Wilson for the man. You could look at that petition and pretty much assume that one was a woman and one was a man, and that was not enough. That's because they're two separate titles. They're two separate jobs. Female state committee member, male state committee member. And I would say I understand the argument in the dissent that this isn't confusing because there's only one candidate. I actually think it's more confusing because there's one candidate. And here's what I would say to that, Your Honors. In the interest of full disclosure, the intervener in this case is my wife, the female state committee member for the 66th Assembly District. Before I met my wife, I had no idea that there was a state female committee member and a male state committee member for every Assembly District. I would bet that most of the people who signed the petition didn't know that. And so when they saw the petition submitted by the other side here, they naturally probably assumed it was one job, state committee member for the 66th Assembly District, and that's what they signed. And that's why it was ipso facto confusing. You don't have to go to a reasonable probability standard. That would have been confusing. They wouldn't even have known that they were petitioning for one person for two jobs rather than one person for one job.
Counsel, there seems to be a little disagreement over whether there was one or two positions open in this district. Is the male position also open in this?
Yes, there was no opponent for the male position, but yes, it was open. There's only an opponent for my wife's position.
Let me go back to your point, because I'm not really understanding it. You're trying to say that if they knew she was female, they say, well, I don't want her to run for that, even though they want her to run. They're signing off, and they're happy to have her be a candidate?
What I'm saying, Your Honor,
If they knew she was, if specifically it said female on it, and if they didn't know,
I think what
they would not want her?
I think what I'm saying, Judge Rivera, is that the way this petition was done, where it just says member of the state committee, most of the people who signed this petition reasonably would have assumed that there's one position. For the 66th Assembly District, there's one state committee member. Doesn't matter whether.
Yeah,
what
but
the
I don't
gender is.
understand your point. So what?
That's confusing. That's exactly why the election law section that we cited here says.
Isn't the
they're
point
less-
that they're interested in having her on the ballot? That's the point.
But-
I don't see your point saying, well, if everyone knew that there's also a male seat, that they wouldn't have signed off on these
But
petitions.
they
I
could
don't
have said,
understand.
there's a female here, is there someone running against her for female? Is there someone running for
But they know
male?
that, wouldn't they wonder that,
You know,
whether it said female or
as to-
not?
and as
Is
to
there, is
matters-
this contested?
As to matters of prescribed content, the election law is very clear, which is the nature of the position. The law is very clear that those petitions have to specifically say what the position here. By having only member state committee, it misstated fundamentally the position, because the position is
Well,
two
no,
positions.
there is only one position. The question is, who fits the criteria to sit in that seat?
No,
And the argument here is she didn't clarify the criteria that allows her to sit in a particular
with
seat.
respect, Judge Rivera, I disagree. There are two positions. There's
Oh, because you got two different petitions?
female state committee member and male state committee member for each assembly district in the state of New York.
Okay.
I think my time is up. If there are any other questions.
Thank you, Counsel. Mr. Schwartz?
Just a couple of brief points. First of all, the party call, which is on page 152 of the record, which I know about because I wrote it, it says member of the state committee. It doesn't, and it says each district shall elect. There's a heading, member of the state committee, and each shall elect one female, one male. It doesn't say what has to be on petitions or what the title is, other than member of the state committee. With respect to the opportunity to ballot, the case I was referring to was Hunting, which is 20 New York 2nd 680. It was a remedy created by this court, like in 1940s, where there was sufficient showing but technical violations, sufficient adequate support for a candidate to run, and the timing of when the petition was invalidated made it impossible for the person to do an opportunity to ballot, and the court said, let's have a write-in. With all due respect to Judge Feinman, the notice that came from a clerk at the Board of Elections was dated July 24th, and the date to do the opportunity to ballot ended on July 23rd. So even if the notice had prompted some quick action, there was no possibility to do a validating petition. There was no reason to believe. We were following the Board of Elections postings every day to see if there was an objection, and it said female, 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 female. When the letter came in, it was like, in fact, it just said,
So how would the opportunity to ballot operate at this point?
the board would have to put a line, to allow a write-in, and then there could be a write-in for Ms. Mintz. So it would be, so it's not an equitable estoppel, it's an equitable remedy. It's not an equitable estoppel argument, it's an equitable remedy. We're saying the board shouldn't have been allowed to act that late, but if...
Put that line automatically?
I don't think so, because that's what opportunity to ballot is like. I think in the general election there's a line, But in the primary election, you don't get that line unless you do an opportunity to ballot, and then you get the write-in line.
Thank you, counsel.